Welcome to Sakshi TV special immigration show with attorney Mr. Chand Parvathaneni from Managing Attorney at law firm of Sim Parvathaneni and Brown. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Banu Inindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on the show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need specific legal advice, please contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, please log on to spblawfirm.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, spblawfirm.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The www.spblawfirm.com site provides you with latest and cutting-edge information on US immigration laws and policies explained in terms you don't need to be a lawyer to understand. So today's topic is US travel, vaccine updates and H1b visa updates. We will continue the knowledge session along with the news and updates on latest immigration followed by a Q&A. Hello Mr. Changaru, we are so glad to have you on our show. Can you please provide us with the new H1b updates this week?
Yeah, thank you so much for inviting me. It's an honor to be on Sakshi TV again. And so definitely I think I would like to share the information on the immigration side based on my work in this field. So this week, the main update is that the deadline for the H1b filings under CAP. So every year we have new H1Bs, the first time H1Bs. We call them the CAP H1b filings. So the deadline for the filings, it ended earlier this week on November 3rd. So as we all know, every March we have this process for CAP filings. So initially we do the registrations. And once you do the registrations, the lottery is done. And the first lottery, the deadline typically is 90 days. So it is typically June 30th is when the file should reach USCIS. And luckily this year, because there were few applicants who did not apply, there was a second lottery. And the deadline for the second lottery was November 3rd. So hopefully everybody that was waiting, that got selected in the second lottery has finished their filings. And as of November 3rd, the CAP filings for this year have come to an end. And in general, overall, the CAP filing season this year went very smoothly. The approvals are very good. And it looks like USCIS, they are following the regulations. And as long as you meet the regulatory requirement, they have been approving the cases. So overall, the process has been smooth this year. And especially with the labor shortage that is going on right now, it is very critical that the qualified employees, they be given approvals, and looks like that is what is happening. That is with in terms of the filings. And another major update that would impact the H1b visa holders or people who are applying for H1b visas very soon is the travel ban. So as we all know, the travel ban has been ongoing since 2020, and finally that has been lifted. And as of November 8th, we don't have to worry about national interest exemptions anymore. Everybody is eligible to travel. However, there are some additional restrictions as far as vaccination requirements are concerned. But overall, it is good news. Now people have a way to travel to US, people who are traveling on non-immigrant visas, such as B1, B2, H4, H1, L1, and so on. So now one should be able to travel to US without the restrictions that have been in place since 2020. And another update that impacts people on H1Bs is the green cards. So everybody typically looks at the visa bulletin that comes every month. And visa bulletin is very critical. And unfortunately, the expectation is that the visa bulletin this month, the bulletin for December that is about to come in another week or so, we might not see major movement, major forward movement. EB3 might not, unfortunately, move ahead. EB2 could still trickle forwards, maybe not as much as we all want, but we probably will see some minor movement in EB2. So overall, these are the updates have from the recent happenings on the employment side of US immigration.
Yes. Thank you, Mr. Changaru. So apparently there was a statement given by this federal judges saying that the US government cannot stop issuing the US visas during the travel ban. Can you please give us more details about this statement?
And again, I mean, the good news is that the travel ban is ending. So this point is moot at this point. But again, to give you an idea of what has happened. So in the month of October, a US federal judge declared that it is unlawful for the State Department to use travel bans to stop visa processing. Because technically, when you look at the travel ban is meant to stop people from traveling from areas of high COVID incidents to US. So the goal is to stop travel from areas with a lot of COVID cases to come to US. But the goal is not to stop the visa processing. But unfortunately, what has happened is that that Department of State, who is responsible for issuing the visas, either a tourist visa B1, B2, or H1 visa or F1 visa. So the consulates, which come under Department of State, they issue the visas. So they were using the travel bans as a reason, and they were denying issuance of visas. So this went to the court, the federal court, and the judge declared that this is unlawful. So this lawsuit was filed by a group of private individuals along with support from ILA, which is the American Immigration Lawyers Association. So they went and sued on this issue, and the judge agreed with them. The judge agreed that it is unlawful to use travel bans as a reason to stop processing of visas. And if you see, for example, China's ban was introduced in early 2020. And the ban for India, it started in June 2020. So ever since then, numerous STEM employees, very, very highly qualified employees, highly qualified the tech professionals, they all got impacted. So the judge said it is unlawful. However, the judge also pointed out, now that the president has said the travel ban is ending on November 8th, this is probably not an issue going forwards. But hopefully, if in the future, if there are these kind of travel bans, this case, I think, will be used to at least argue that the Department of State cannot stop issuing visas. So this is a good reference case for the future. But going forward, since the ban is anyway removed, this is probably not a major issue, and the issue is currently moved.
Yes. Now, market research analyst is now considered as a specialty occupation. What are the advantages that people can take?
So again, when we say specialty occupation, what does it mean? So in general, this comes into picture when somebody is applying for a H1b visa. So any time the company, the petitioner, petitions for a H1b visa to USCIS, one of the major requirements they are supposed to meet is that whatever job position, the occupation that they are filing for their employee, it has to meet the standard of specialty occupation. From a layman term, what that means is that the job, whatever job the company is petitioning, that job, that occupation has to meet the occupation standards. What that means is to enter that occupation, one should require a bachelor's degree. That is required. A bachelor's degree is required. But again, just any bachelor's degree is not enough. The rules say that a bachelor's degree in a specific specialty should be the minimal requirement to enter into that occupation. Only then they can request for a H1b visa. So what that means is, for example, somebody is applying for a software developer job. A software developer occupation, in general, one requires a minimum of a bachelor's degree in computer science or equivalent. Just any bachelor's degree is not relevant for the occupation of software developer. Hence, the software developer meets the specialty occupation requirement, and hence one can apply for H1b for that occupation. So typically that is what specialty occupation means. And market research analyst. This was also another popular occupation where a lot of companies file for H1Bs. However, over the last couple of years, USCIS has denied a lot of such cases. And their argument is, so they look at something what is called as Occupational Outlook Handbook. And their argument is, Occupational Outlook Handbook says a bachelor's degree is required. It does not really say a specific specialty is required. And USCIS interpreted that to mean that since a generic bachelor's degree is required for entry into this occupation, it is not a specialized occupation. It's not a specialized field. And hence it is not a specialty occupation. That was their argument. And they went and denied a whole bunch of cases. So people went and sued them in the court. So a lawsuit was brought about by American Immigration Council, supported by ILA and various other law firms. And what happened was USCIS entered into a settlement for this class action lawsuit. So USCIS settled, and they said that they will start looking at the previous denials, and they also agreed that this is a specialty occupation going forwards. And again, what that means is this is a very significant rule. This is a very significant settlement because even though it is only for market research analysts, it also impacts other occupations, for example, such as computer programmer, which also had an issue in the past few years. So a lot of these occupations, when you look at the Occupational Outlook Handbook, sometimes they're not that clear, which gives USCIS a chance to interpret it differently. So in general, I think this ruling helps in narrowing down the definition of specialty occupation. It will help people to fight specialty occupation denials, even for other occupations in the future, when you look at the way this case was argued. And from a practical perspective, what that means is when anybody is applying for a H1B visa, we really have to make sure we are describing the specific duties, because a mistake a lot of people do is they explain only the generic job duties. They don't explain the specific job duties. So the goal is when anybody is applying for a H1B visa, if one goes ahead and explains the specific job duties, explains how a specific specialty is relevant to those job duties, it gives USCIS an easy way to approve those cases. So in general, we can expect to see market research analysts getting approved easily in the future. And also the arguments that were used for this case will also help us to argue cases better. And what that means is USCIS cannot arbitrarily start denying cases using this specialty occupation requirement into the future.
Yes. According to a new US bill, it is said that there could be an increase in the prices of the application fee of H1B. Is it true, and what are your views on it?
Sure. Yes, currently there is a bill under consideration. And before we go into the bill, it is a very common misconception, at least in US, for some people who are ignorant about H1B program, that H1B is used for hiring cheap labor. Again, the people, the companies know that is not true. Many people know that is not true. But unfortunately, there is this misconception that H1B is used for hiring cheap labor. And in reality, that is absolutely not true. H1B is a program that is used for hiring the best and brightest across the world. And the reason for that is, if you just take a look at the filing fee for H1B, currently some companies, again, depending on the size of the company, it could vary, it will vary. But again, for some companies, they pay as high as 6,460 just to file for a H1B transfer. And that is not including the premium processing fees, that is not including the attorney's fees. So if you include the premium processing fees and attorney's fees, some companies right now pay as much as $10,000 just to file for a H1B. So that itself shows that how expensive this program is. And that clearly tells that this program is beneficial for the employer who's doing a business. It is beneficial only if they hire the best and the brightest, because they have to pay such a high salary, and it is not really useful if they start hiring cheap labor. That is one part. And if you look at the wage requirements for H1B, one has to follow the standards required by the labor condition application. What that means is you cannot give any random wage. The wage has to meet minimal requirements, the minimum LCA requirements. So overall, if you look at this H1B program, it is a very expensive program from an employer perspective. But again, the reason it is there is because this program motivates companies to hire the best and the brightest, and which is what is happening right now. And this H1B program is really benefiting US a lot more because you are able to attract the best and the brightest. That being said, yes, there is a bill and they're trying to increase the H1B fees. What the current bill is trying to do is they're trying to tack on an additional $500 fee. And that would not only be for the H1Bs, it would also be for the H4s, which is for the dependents of H1B employees, and for a whole bunch of other non-immigrant visas too. And again, I think this bill will be voted very soon. It is a part of the reconciliation bill. So if you look at the bills that are being discussed in the House, it is in that bill. Whether it will pass or not, whether it will pass in the current fashion, I'm not sure. But again, definitely they're considering increasing the fees. And the most recent fees increase happened last year, the fees that would target H1B. So last year, the premium processing fees, it used to be $1,440. It got increased to $2,500. That happened last year. So again, this year, again, depending on the passage of this bill, this is a high possibility. But again, hopefully, I hope they do not do this, because the more the fees gets increased, it kind of demotivates the employers. And again, with the kind of labor shortage we are currently seeing, we really require highly talented individuals to work in US to fill up a lot of jobs that are currently not being able to be filled up.
Yes. As we all know, you are an attorney yourself. What was the major issue that you had to deal with or your clients had to deal with, especially during the COVID ban?
Right. I think the most practical thing that I saw was a lot of employees, they postponed their marriage plans, unfortunately. And I have cases where people are so frustrated and they just want to go to India and finish their marriage. And I'll tell you the reasons for it. So the travel restriction started in 2020, early 2020, in March. Ever since the emergency came into picture, we had travel bans. And the problem with a lot of H1B employees is that they go to India, they get stuck, they can't get a visa, especially because of all these travel bans. And Department of State using these travel bans to stop the visa processing. And unfortunately, some people, they had family emergencies. They did not have a choice. If it is something like a marriage, people were able to postpone. But people had family emergencies. Somebody in the family got really sick. They didn't have a choice. They had to travel because family is very important. Unfortunately, I saw people got stuck. Some people lost their jobs because they were not able to come back, and they could not do their jobs from India because some of the projects are sensitive and you cannot really do the work from outside the country. So I know of some sad cases where people lost their jobs, lost their career because they traveled to India, they could not come back because of various travel bans. And I also had a lot of cases where, I had one case where the spouse unfortunately died, and they could not get any support from the family because family was living in India and the family cannot come to US because B1, B2, they could not travel because of the travel ban. So unfortunately, I think COVID impacted everybody in a very big way. And unfortunately for immigrants who are living in US, everybody has family back in India and people are separated and not traveling for so long, for close to about 2 years now. It's a big thing. I mean, you're not able to see your family. I mean, people could not go to India to get married because once they go to India, they cannot come back because of visa issues. People who had severe medical emergencies in the family, they were not able to travel back. So it was very heart-wrenching to see those kind of scenarios. I mean, very, very highly talented employees being stopped because of these travel bans. And that also impacted the economy because anytime H1B employees, most of the H1b employees are very highly paid employees. They are in highly professional jobs. So anytime that particular employee is not able to work, you are also impacting U.S. economy in the end. So I think this was a ripple effect, and hopefully, with the way I think the vaccines came about, and at least we just hope there is no other new wave, further waves. And with also President Biden removing this travel ban finally, I think it's going to help everybody and get back to living their lives normally like it used to be before COVID.
Yes. So now we're going to discuss about a specific issue. Last month, a group of Indian nationals have filed a case against the US immigrations, saying that the L2 visa holders cannot be working until they get a work permit. Was that true, and what happened during the case?
So again, this lawsuit was recently filed, and this lawsuit was filed by an attorney who's a very good acquaintance of mine. He's a very efficient attorney, so I hope he wins this lawsuit.
Yes.
And I'm closely monitoring this lawsuit. And again, before going into this lawsuit, what is the issue? So the issue is that the spouses of L1 visa holders, the spouses of L1 visa holders, they come under L2 status. They typically have they're authorized to work typically. And same thing with the spouses of H1b employees. So the spouses of H1b employees who are on H4 status, they are able to work if the primary H1b spouse has an I-140 approval. So they are allowed to work, but again, there is a process. So in order to work, they're supposed to apply for a work permit. They are supposed to apply for a work permit through a form called I-765, requesting work authorization. So the problem is, in the last couple of years, getting an approval once you apply for I-765 is close to a 10-month to a 15, 16-month process. So it is close to a year and a half process. So what has happened is, so when the rules were made, the intention was to have the spouses immediately get work authorization. The makers of these rules, they never intended that this will take close to a year and a half just for somebody to get work authorization. So clearly, it is impacting people in a negative way, in a way that the law did not intend, which is why this lawsuit was filed. So the lawsuit requests that there should not be any waiting time, and the spouses should be allowed to work immediately. And according to this lawsuit, USCIS is taking away highly educated and skilled workers from their employers, especially when there is a huge labor shortage. That's another big thing. And according to the attorneys that filed this case, L2 visa holders qualify for employment incident to status. So what that means is there should not be another work permit application. And again, I'm also monitoring this lawsuit. We don't know what will happen, but it is good to know that this lawsuit is filed. And at least down the line, there is a scope for USCIS to make changes into their rules. And that being said, one interesting thing that this lawsuit argues is that a couple of categories who apply for work permits typically, they get a 180-day automatic extension. So a lot of people who typically have work authorization, when it expires, there is already a process in place where people get 180-day automatic extension. And I think my understanding is this lawsuit also requests that kind of 180-day automatic extension to L2 and H4 categories. And again, this is a lawsuit in progress. We all need to monitor it, and hopefully if this gets adjudicated in the plaintiff's favor, it will definitely make an impact and help a lot of people on L2 and H4. So I think something to monitor in the next couple of months and see how it pans out.
Yes, I hope it turns out really well. Now, Mr. Chandgaru, we know that COVID was a huge loss, and especially for new entrepreneurs. What do you think the entrepreneurs or newly entrepreneurs had to go through, especially during the COVID restrictions in USA?
Right. So for entrepreneurs, travel is a major thing because people travel, they share ideas, they have to travel internationally because sometimes you might have to do business internationally. So the whole factor that people were not able to travel, I would say impacted entrepreneurs in a big way. A lot of entrepreneurs use B1, B2 visas. I mean, they travel for business reasons. They travel on B1, B2, the business visas to improve their business. So not being able to travel internationally was a major impact to entrepreneurship. And there is another visa program. It's called the EB5 program. So even the EB5 program got indirectly impacted due to COVID. So if you look at the adjudication timelines for EB5 program, they increased drastically. Right now, the EB5 program for entrepreneurs, it's in a huge disarray. This program, one of the pieces of this program for regional centers, the program sunset on end of June this year. It has not been renewed, and that also impacted entrepreneurs very badly. So overall, again, we do not really have a per se entrepreneur visa right now, and because of COVID, we did not really see anything specifically done for encouraging entrepreneurs in the last 1-2 years. So overall, I think the inability to travel internationally and also domestically due to various travel issues, COVID bans, etc., and EB5 program not going as well as typically people would have wanted it to go, I think definitely impacted entrepreneurs in a negative manner.
Yes. I wanted to discuss a little about the F1 visa. It is said that US government is giving preferences to student visas. Is it true, Mr. Changaru?
So again, I think there was recently US Consulate General in India give an interview, and they did confirm that the student visas will be given preference. So what is the reason for that? So the reason for that is, as we all know, in the last couple of months, because of various travel bans and also staff shortages, we had a lot of issues with getting visas at the US consulates in India. Especially Department of State did not process a lot of visas because of travel bans. And now, as we all know, on November 8th, this ban is coming to an end. And what that means is once the ban comes to an end and Department of State also starts issuing various other non-immigrant visas, either for B1, B2, H1, H4, and various other visas, people will start rushing to request visas because over the last couple of months, they have not been able to apply for visas. And I think the consulates, they understand that they will see a rush to request various non-immigrant visas. That being said, for students, so students, unfortunately, they cannot wait long because they have to be here in US by the time the schools start, the universities start their academic programs. And right now, the new spring semesters typically will start in January. Typically, about second week of January is when most of the universities will begin their spring semesters. So it is very highly important that the student visas be prioritized and be issued because people can make their travel plans and either try to come to US end of June or early January before the F1 program start. And because of this reason, I think the US consulates will prioritize F1 visas in the next month or so, especially keeping in mind that the spring semester will start in January.
Yes.
That being said, I think now I think all the visas will slowly start getting issued. And I think especially the B1, B2 visa seekers who have not been able to apply, yes, I think now is a good time to start looking for interview dates and start getting your process started.
Yes. Thank you so much, Mr. Changaru. I think we had an amazing show which discussed vast majority of topics. It was so nice having you on our show.
Yeah, thank you so much for inviting me.
Yes. Thank you so much. And you're watching Sakshi TV and I'm your host Shivani Raj. Thank you.